So welcome to the viewers of this installment of EJIL Live. And we are featuring an article by Sungjoon Cho and Jürgen Kurtz called Convergence and Divergence in International Economic Law and Politics. And I have with me Jürgen Kurtz, one of the co-authors. Welcome.
Thank you for the invitation.
We're delighted to publish this. It's a very hot topic. And we already saw swallows, signs, when people who usually taught international trade started teaching trade and investment, and people who were investment specialists began to teach also trade.
Yes.
There might be many reasons for that, which have nothing to do with the field and more with pressures of deans and things like that. But of course, it all came to a very visible convergence point where, with the Philip Morris case, when
Yes.
The same company around the same dispute bought parallel action in the WTO
Yes.
and under an investment arbitration treaty. Now, let's go back a little bit in history. These two worlds really developed separately from each other in some way. The universe of arbitrators, for example, or panelists of the GATT and WTO was a very different universe
Yes.
than the arbitrators in investment arbitration, which tended to come from the world of international commercial arbitration.
Correct.
And there was also a very dramatic difference in the structure of these treaties, especially as concerns considerations for public policy.
Correct.
In other words, in the WTO, in the GATT, there is built-in Article 20 with exceptions for public
Yes.
morality, the environment, a whole set of considerations of public policy. And it is still the case that in most of the thousands of bilateral investment treaties, there's just no exception clause.
Yes.
Now, the standard approach or interpretation in the field was that GATT-WTO was negotiated by OECD countries at arm's length with a great sensibility. Well, yes, we don't want to discriminate, but sometimes we have overriding public policy, whereas bilateral investment treaties was a skewed universe where the capital exporting countries were just interested in protecting their investors and not so interested in whatever competing social policies that the receiving country had. And it is most dramatic in the NAFTA,
Yes.
where within the same agreement you have an exception clause under trade and no exception clause under investment. And as everybody knows, I've even seen lawyers arguing, saying, well, if they didn't include it, it's meant as a signal to the arbitrators that they should not be able to take into account.
Yes.
So tell us, against this background, which seems to be Venus and Mars, how do you explain the convergence? What is driving it?
So I think the first principal driver is an economic one, that what you have increasingly are trade and investment as interlinked economic phenomena. So if we look back in history to the sort of the early days of the GATT with still relatively high tariffs at that time, foreign investment became another alternative mechanism of penetrating markets, right? You used foreign investment to jump a tariff wall. With the erosion of tariff barriers, what we're finding is the significant growth in global value chains, integrated production networks. So the world is in a much more fluid place where both trade and foreign investment are inherently interlinked as economic phenomena in the contemporary setting. So I think that's the first driver. Another driver, I think, goes partly to your point about the plaintiff bar in investment law, which is aggressive and creative in a very powerful sense. So where it's possible to package disputes in or use different fora to seek outcomes for claimants, the lawyers have become far more creative and willing to sort of move across disciplinary boundaries and use insights from one system when drawing strategies or approaches in another. So those are kind of two big ticket drivers.
There must be a third one, which is if you have a trade dispute,
Yes.
first of all, you have to mobilize a government.
Correct.
So, the important
That's
state of Antigua suddenly discovers an interest in internet gambling, but it's really used as a foil for the internet gambling industry, but you have to find a government that will bring the case. And also the remedy you give is often very disappointing because it's a cease and desist, but you don't recover loss for the past. So one of the drivers must be trade lawyers saying, well, why don't we, when at all possible, take the route of investment arbitration? A, we don't depend on the government, we can do it, and B, we are going to get a much more rewarding in a double sense.
Yes. No, I absolutely
outcome.
agree. The political filter in state-to-state dispute settlement is extremely tight. It's partly what you've outlined, which is you need to be able to convince a state to espouse a claim on your behalf, and that then naturally engages issues of reciprocity in terms of the counterparty and the political relationship that those two states exist in. So there's always an uncertainty in invocation of rights in the WTO, whereas in investor-state arbitration, there's no filter by a state. It's purely a question of the commercial imperatives of the claimant and the dispute. So
if we can now switch to the doctrinal for 1 minute. And of course, the doctrinal being, as always, an expression for some values and some interests. Yeah. So the more they converge, the less tenable does become the claim of the investment bar.
Correct.
That social policies exceptions were not contemplated in the agreements, and then we get all the huff and puff which we saw in the Argentina investment cases, etc. But how is the bridge being created doctrinally? How is the concern deeper or shallower, but nonetheless the concern for social policy that is reflected in Article 20 of GATT or 14 of the GATTs, etc., how is that being bridged in the investment arbitration treaties where we don't have something like that written, although in the new ones, it's coming in.
So the landscape is diverse, as you've just touched upon. So there's a variation between the vast bulk of the treaties, which date back to the 1990s, where the imbalanced structure that you mentioned still holds true, no exceptions. And then the newer treaties, CETA being a very recent example, where you have a very thick set of exceptions. What is interesting on the doctrinal turn in investment arbitration is, and this is partly the motivation for our paper, and it's one of those periods in my life where this has had a very long genesis as a series of conversations I've had with Sungjoon over years, where we've both had the same reaction to a series of jurisprudential developments. What we found is that what's happening in investment law is that what some arbitrators are doing, so it's by no means generalisable, but we regard this as the most defensible part of the jurisprudential spread. What some arbitrators are doing is that they are effectively re-engineering policy-type questions on questions of obligation. So where you have structures or jurisprudential tests, they're being tweaked in such a way that that the responding state is given some appropriate latitude by which to plead and present the justification as against the claim for breach.
So the way I read that case law, tell me if you agree with me, that in a way it's a variation of aims and effects.
Correct.
That they say there's an obligation not to discriminate or to be protectionist of your domestic market, but it's not only that your measure should not produce that effect, but it must not be adopted with that aim of producing that effect. So if the government is introducing a measure with the purpose of protecting the environment, which coincidentally has indirect discrimination, creates a disparate impact, that should not be considered a violation of the obligation undertaken under the national treatment or non-discrimination provision in the investment treaty.
That's exactly right. And I think actually what your point you put your finger on a very nice difference between the two systems, because that's exactly what's happening in investment arbitration, again, in a slice of the jurisprudence, because it's so disaggregated in a sense. But that's happening, and we regard that as a strong, sustainable form of legal reasoning in relation to a certain set of disputes. And what it does actually, in comparative terms, is it brings into question some of the assumptions about the resistance to a purpose-based test in WTO law, because one of the objections to a purpose-based test in WTO law, there are many, but one has always been a claim that it's too sensitive, that there's something, you yourself have written on this point, that it's somehow improper for a third-party adjudicator to second-guess the purpose of a state. But what you have in investment arbitration are a series of reasonably good attempts at doing this in a carefully objective and neutral manner. So we take the view that, again, perfectly even-handed, that it's not always the case that WTO jurisprudence strikes the better balance.
So here's my question. Do you actually see signs? Because that's what one would predict, that yes. If aims and effect, or what you call purpose-based analysis, is becoming more prevalent and acceptable and also more refined, because yes. They don't have an exception clause, so they have to do it in a fine-tuned way. Do you see signs that the resistance, both by panels and the appellate body, to aims and effect in trade disputes is weakening?
No, sadly I don't. I mean, I think there's receptivity, and this is a criticism I have actually of the WTO. I think there's receptivity in investment arbitration, partly because it's under such significant legitimacy constraints. There's receptivity to considering the position of the WTO jurisprudential body. There's very little reverse cross-fertilization. There are sort of some small points, but one sees clove cigarettes, for example, a reversion back to the past. So that hasn't occurred, and actually there's a sophisticated legal criticism of the sorts of claims that there's a criticism of treaty practice that we touched upon a moment ago, where you mentioned that some of the newer FTAs like CETA include exceptions chapters, exceptions provisions modelled on GATT Article 20. The criticism goes that, well, that's a retrograde step, because by including exceptions in, what you can do is it has perverse incentives, because adjudicators are less likely to consider purpose at point of obligation. I mean, and
even make the doctrinal point. You see, when they want to, they put it in. So if they didn't put it in,
exactly.
But of course, historically speaking, a sophisticated arbitrator should not be impressed by that. So here is a question of sort of prediction.
Please.
The WTO is in a certain crisis.
It is.
We all know the failure of Doha, etc.
Yes.
And there's also the dispute settlement provoked by the Americans in part. But whereas despite all the hues and cries over state investor, around TTIP, etc., it's still a flourishing industry.
Right.
So if you take, as you do, a holistic approach, because that's one of the most fascinating things about your piece in EJIL, we're going to look holistically at trade and investment. Yes. Would you predict that because just the stream of decisions and the consistency of practice in investment arbitration is going to overwhelm the trade, and eventually it will just force that, and the same sets of lawyers are now arguing the same cases. Yeah. So is your prediction that, you say sadly not, but what's your...
So my sense is there's fragility in both systems. You've pointed out the fragility in the WTO, and I agree with you. There are some serious threats, sort of curious threats in a certain sense, but the US position on the appellate body at the moment has really led to enormous standstill in that part of the system. But investment law has also its own levels of fragility. All right, so there's significant uptake in cases, and that's remained relatively stable. But what you find are a variety of responses by states to the sorts of claims that are being brought, not always constructive. So let me just flesh out a couple, and then we can get a sense of what's happening. One thing that's quite common for both developed and developing states to do when they have never had a case before is when the first case hits the desk of the Ministry of Justice, as it normally is, or they lose the case, there is a very quick feedback loop where you'll see a reaction to reassessing dispute settlement in a non-principled manner. So let me give you an example. Australia, the plain packaging case. The case had not even been decided when the government of the day decided no further investor-state arbitration would be included in future investment and trade agreements. Now that's been overturned after an election, but you see that kind of responsiveness, that reaction. And
I must drop a footnote.
Please.
It's so hypocritical.
I agree.
Because as long as the investment disputes took place in those
absolutely.
South developing countries, it was wonderful. This is justice, this is protected.
Exactly.
The minute it came to their own system, which when they drafted these things, they never imagined that they would be on the defendant side. Suddenly, it's an unacceptable mechanism.
I chose Australia for a reason, because it's my state of nationality. Yeah?
Tell me, do you notice that if it's a question whether the investment bar on the investor side is beginning to realize that if they press too aggressively the no social policy, in a way they're cutting the branch on which their $10 a minute fees are.
I think that is happening, and actually I think what the usual critique about investment...
I should have said $20 a minute.
The usual critique about investment arbitration is that it's tilted in a pro-investor direction, that there's an embedded bias of sorts. That may have been true once, but in the last, I'd say 5 years even, I've noticed a significant shift in the other direction. So it's not just that the plaintiff bar is hearing those signals, I think the arbitrators are as well. And I think there's a significant, a not insignificant number of awards that take an unprincipled pro-state orientation, which again is problematic, because the difficulty with investment arbitration, I've taught it for now over 15 years, the difficulty when you teach it as a teacher, it's almost impossible to identify representative lines of case law. It's very difficult to predict, not outcomes, but just methodologies, the way in which arbitrators will adjudicate. So yes, the bar is shifting and the arbitrators are shifting.
I can't resist a little vicious comment here, because you say the bar is shifting and the arbitrators are shifting as if these are two separate sets of people, whereas we know that very often you're an arbitrator in one case and investor plaintiff in another case.
Correct.
So one last question. Yes. Our focus until now in all my questions has been on the convergence trend. But your article is convergence and divergence, and you don't, so where would you say remain, apart from the obvious things that investment arbitration is individual plaintiff generated, the structural differences, but are there deeper divergences that remain?
I think there are. I mean, the biggest divergence is probably going to centre around the test piece of the EU's new investment court. Because if you think about, so one of the arguments Sungjoon and I are making, and we think it's defensible, is that there is a subset of the case law that is jurisprudentially superior for the reasons we outlined, that it offers a mature reconciliation of market and other values. So it's sustainable, it will build state commitment. Now the question becomes, absent any structural reform, how likely is it that investment treaty arbitrators will rule in that direction, or will there still be this continued splintering of adjudicatory choices? Now, on one view, the best chance of getting that type of superior line of jurisprudential reasoning is if you also have structural reform. So you move away from a system where the incentives of arbitrators are to rule in line with reappointment in future awards. Now, the big test case is the EU's investment court, which is explicitly modelled on the WTO, but still preserves, importantly in my view, standing rights to non-state actors. So it's an important hybrid between the two choices. Now, it's run into some pretty significant roadblocks so far, including its own internal roadblocks. So far, there's only been two counterparties that have been prepared to agree to it, Vietnam and Canada. There are a whole host of state parties that seem fiercely opposed to it, including the United States. So in the NAFTA renegotiations, we're looking at a possibility of no investor-state dispute settlement whatsoever. So I think there are clear variances in preferences, revealed preferences of states' parties, but this will be the big test case of how far we move towards a reconciliation between the two systems.
And, you know, if the CETA court comes before the European Court of Justice, it's not impossible that they would just say that it's incompatible with European law because they are so jealous that no other jurisdiction will ever pronounce itself on questions of European law. We will wait and see. I think, turning once again to our viewer, you all have a sense that this article, apart from a really serious engagement on a doctrinal and policy level, has ramifications which transcends the specific issue. And I hope this interview with Jürgen Kurtz will whet your appetite to turn to the article, read it, study it, and reflect on it, and maybe respond to it on EJIL Talk. Thank you, Jürgen. Thank you all very much.
Thank you.